All right, Mr. Davis or Miss
Hey.
Davis? Okay,
Yeah,
Mr. Davis.
I'm the beneficiary of Dwayne Davis right here. The beneficiary.
What is it?
Are you Dwayne? Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does reside there.
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it.
Before we even step into this courtroom, you need to know something wild is about to unfold. Today we're watching not one, but two defendants try to use sovereign citizen-style arguments in completely different courts, and both judges shut it down fast. In the first case, a tenant facing eviction refuses to even admit he's himself. He calls himself a beneficiary of his own name, dodges basic identity questions, and tries to turn a simple unpaid rent case into some kind of philosophical debate about legal personhood. The judge, not having it. Then in the second courtroom, things take another turn. A father behind on child support tries to argue that the obligation is a contract, not law, and even brings up maritime court and gold-fringed flags. Yes, you heard that right. Two separate hearings. Two different judges. Same core tactic. Challenge the court instead of addressing the actual legal issue. And what you're about to see is exactly why those arguments almost always collapse in real courtrooms. Watch closely, because every exchange here reveals how procedure beats theory every single time.
Mr. Davis or Miss
Hey.
Davis? Okay,
Yeah, I'm
Mr.
the beneficiary of Dwayne Davis right here. The beneficiary.
What is it?
Are you Dwayne? Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does reside there.
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it. Say it again.
All right, okay. Thank you. Calling case number 22393437. This is Pasadena Investments LLC versus Dwayne Davis Jr. and all occupants at 2170 East Jefferson, Unit 1007.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Your Honor, Mr. Davis at this time owes $6,706, court cost of $157. This is a subsequent hearing.
All right, Mr. Davis or Miss
Hey.
Davis? Okay,
Yeah, I'm
Mr.
the beneficiary of Dwayne Davis right here. The beneficiary.
What is it?
Are you Dwayne? Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does reside there.
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
Right here is the critical moment where this case starts slipping away from the defendant, and it has nothing to do with rent yet. Notice what the judge is doing. He's trying to establish a basic legal fact. Who is the person occupying the property? That's foundational in landlord-tenant court. You can't argue defenses, payment issues, or lease terms until the court confirms the occupant's identity. But the defendant keeps substituting the term beneficiary, which is a classic sovereign citizen tactic meant to separate the human from the legal name. The problem? Courts don't recognize that distinction in tenancy law. From the judge's perspective, this looks like refusal to identify as the named defendant. And procedurally, that's dangerous, because if no defendant appears, the court can move toward default. So while the defendant thinks he's making a jurisdictional point, What he's actually doing is removing himself from his own defense. And that procedural gap is about to matter a lot.
I don't fully understand it. Say it again.
All right, okay. At this point, I don't see anyone who resides at 2170 East Jefferson, Unit 1007. If you do reside there, please make the court aware of it.
Okay.
Your Honor, since the defendant has not identified himself as the defendant in this particular matter.
I just did. I just told you I'm the beneficiary
Your Honor,
of the name.
Your Honor, since the defendant has not identified himself as a person in this property, he's attempting to try to act like he's a sovereign. This property is owned and is an apartment building. We're asking for a default judgment at this time. If he decides to pay it, that's great. If not, we'll be moving forward after time expires.
Before we proceed with this matter, can I ask the director of the beneficiary? I'm talking to the plaintiff, sir. My legal person, I'm showing you right here, a corporation. Can you write me in 21 days and provide me evidence that you have legal?
Your Honor, none of that
I just want to know.
required by law in this court. I'm asking for a default judgment this time. Quit wasting the court's time. If he wants if he wants to file the appropriate court paper or identify himself to the court as you've requested on numerous occasions, then we can proceed forward. At this time, playing these legal games is against.
I have a birth certificate right here.
Against the law. Two, we provide the court with a lease agreement. We provide the court with the ledger. We're asking for a default judgment.
The court is in receipt of a summons, a complaint, a demand for non-payment of rent, as well as a lease agreement.
The summons was never notarized.
Signed with Dwayne Davis Jr., as well as the proof of service. Mr. Davis, Dwayne Davis Jr., how much is your monthly rent?
I want to say 900.
When's the last time you paid rent?
Long time. Siri paid my back balance, but Pasadena never put it to my account. So I consider Pasadena either took the money or what. I don't know what they did with it, but Siri definitely paid it. It's on the record. It's on my the record with the Siri. You can find it in their profile. But they're supposed to pay my back balance.
I don't know. I can't find it in my profile. So you qualify. Sarah paid. How much did Sarah pay?
They paid up to like September, but they didn't pay they're supposed to pay July, August, September, but Pasadena never put that to my account.
Your Honor, if it wasn't applied, my client didn't receive it. That is not our burden.
Okay.
It's his burden.
But that's in documents though that they were supposed to pay. I have it in documents.
Your Honor, I'm not going to sit up and argue all day, Your Honor. Bottom line is, the money is for his benefit. It is not for my client's benefit. Just like paying a mortgage payment. If I send a mortgage payment in, if it's not received, it's still on me. If you send a mortgage payment on my behalf and it's not received, it's still on the person who has the mortgage. He's the renter. It is his responsibility to have the monies paid or to whoever's paying on his behalf that we receive it. We have done everything we're supposed to do. The documentation speaks for itself. At this time, again, I'm requesting for either default judgment or judgment by hearing.
And then I'm talking to the plaintiff. Can you just write me and saying that you have authority as a public servant to me?
Your Honor, I am not writing.
Excuse me,
I'm not
Mr. Davis. This is a landlord-tenant court. This is summary proceedings. This is the second hearing, and you're afforded legal counsel. Legal counsel was available. They said that they could not assist you at this matter. Are you even identifying yourself as Dwayne Davis Jr.?
No, I'm the beneficiary of that name.
So are you not Dwayne Davis Jr.?
No, I am not. I am not.
Okay. We are entering. The court has not received the call or answer from Dwayne Davis Jr. Does anyone on this Zoom reside at 2170 East Jefferson, number 1007? Is anyone present who lives in that property on this Zoom?
Your Honor, again, no one's responded, asking for my default judgment. We can submit it to the court before the end of the day, along with a full ledger.
Default judgment granted.
And just like that, the case is effectively over. What just happened here is a textbook example of procedural default in summary eviction court. The judge gave multiple opportunities to confirm residency and identity. The defendant never clearly did. From the court standpoint, the named tenant failed to appear and answer the complaint. Once that threshold is crossed, the judge doesn't even need to analyze rent disputes, payment programs, or assistance claims. None of that matters procedurally if the defendant doesn't step into the role of defendant. That's why the attorney kept emphasizing identity, because legally, that's the gatekeeper issue. And notice something important. The judge never argued ideology, never debated beneficiary theory. He stayed strictly on procedure. Courts don't resolve philosophical disputes. They resolve cases. And in eviction court, if you don't acknowledge being the tenant, the court treats you as absent. That's exactly why default judgment was inevitable the moment identity was denied.
Thank you, Judge.
Please submit the paperwork. Call, you're free to leave. Well, nobody identified themselves, so
I'm wondering if you got those check stubs that I've entered in.
I didn't get any check stubs.
So
Oh yeah. Wait a minute. I did get some check stubs. Yes, you were the one that did have them. Yeah, I had a question on those because you got 2 support notices on each stub. So do you have more than one case?
yes, sir.
Okay, how many children do you have?
2.
Okay, this one and another one?
Yep.
Okay, because I was trying to figure out, I have a feeling that what's happening is they are maxed out on how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they
Right.
issued the warrants.
Right. If you owe
And-
$100 and they only collect 70, you're gaining $30 a month in arrears. And once the
No.
arrears hit a month, well, that's why I was asking, because the amount of child
Those-
support that is are these weekly checks or monthly?
Weekly, sir. It's
Okay.
440. They was receiving that, and at the time,
And how much did they say that you owe?
just now recently,
Yeah.
they said I was in arrears is 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now
But-
you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you.
But my whole thing is, I wasn't paying because last year, April,
Mhm.
they got a $5,000 check on my behalf
From whom?
from an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000?
Yep, it was.
Okay, and that should have gone against any arrears. Now their next question would be, are you sure they got it?
Child support?
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they got
Okay, because what I would do if I were you is ask for an accounting of the case to make sure they got it. An accounting will give you a computer readout of every month that you owe and every payment that's been made. And they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file. So the court does not know how much your arrearage is unless they apply for a show cause. Okay.
Okay. And I haven't been paying recently because I was under the impression that the obligation is $445 a month.
Well, it looks like how have you not been are you not employed anymore?
I'm at work right now.
Okay, well, it's because the employer automatically takes it out.
Right. I just started this job, and
Okay, then you have to notify the front of the court what job you changed to, so that they can apply it to the appropriate, because they issue an automatic income withholding order. Again, that does not go in the court file because it contains some very specific information about you, and you don't want that public information.
this is what I'm trying to say to you, sir.
Mhm.
They received $5,000 last
And I told you what to do to deal with that.
April.
Yeah.
I was under the impression covered the rest of the year. I did not know that they.
No, they don't cover anything forward. They only cover things currently owed.
Right. Okay.
They can't hold money forward. If they have an overpayment within 48 hours, they will send you back a check for the overpayment.
Okay, well, they still was in breach of contract.
There is no contract. This is the law. That's not a contract.
Is this
They're
Zoom
following.
just about child support?
Yeah, sorry, Ms. Cry. That's what his motion's about.
And
So,
why did I have to join? I'm thinking this for
well,
my
because
motion.
you have a motion.
Yes, I do.
I have a motion for child support and an amended motion for child support. Those are the only motions before the court.
My motion wasn't about child support.
What was your motion about?
It was basically just for me trying to get his rights and stuff revoked. I did all this
We
stuff.
we don't revoke rights in a parent in a family law case.
You should have been getting some paper. I did all this stuff.
Well, that motion would be automatically denied because we do not revoke parental rights in a family law case. That has to be done in a neglect case.
In a what case?
An abuse neglect case.
So why did they have me filling out the papers?
I have no idea. I don't know what papers you filled out. I don't have them. Okay. So I'm sorry, I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
Okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
The front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules and the statutes in doing so. The court tells them when or if child support should be reviewed. And again, I've informed you, sir, Mr. Miller, you have the right to ask for a child support review if that's what you're asking for. But yeah, if you're not paying support, they're going to be hauling you in to explain why you're not paying.
Well, I also was sick.
Okay, that's fine too. But again, you're going to have to explain why the payments weren't being made and why you owe.
Payments wasn't being made because I was under.
You're under a misapprehension, not an understanding. So that one I could tell you you're wrong on. So the best you can do is ask for an accounting to make sure that all money is accounted for and all payments are accounted for. Now, do you want this sent to the front of the court for a child support review?
I want this case closed and dismissed.
It's not going to be closed and it's not going to be dismissed.
So even though they were receiving the full monthly obligations, it's okay for them to.
If you owe, they're going to haul you in to find out why you're not paying the amount.
And we wasn't receiving I wasn't receiving no full amount.
Well, ma'am, part of this, you're not going to receive the full amount. You're on state aid. The reason that this case was brought, it was brought by the state of Michigan because of your state aid. When you're on state aid, the state mandates the child support be paid in accordance with the law, and then they confiscate portions of that child support to reimburse the state for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is.
Here it is, the pivot that shows the same pattern in a completely different type of case. The judge has just explained, very clearly, that child support is statutory. That means it exists because of state law, not agreement between parents. But the defendant shifts into maritime law territory, referencing flags, contracts, and jurisdiction theories often seen in sovereign citizen arguments. The issue is, none of that intersects with family law enforcement. Child support orders come from statute and court authority tied to the child's welfare, not commerce, not contracts, not admiralty. And watch how the judge responds. Direct, factual, and dismissive of the theory without escalating conflict. That's typical judicial handling of these arguments. Acknowledge, correct, move on. Because legally, once a court has subject matter jurisdiction over family law, maritime concepts are irrelevant. So what we're seeing again is a defendant challenging the system's legitimacy instead of addressing arrears or payment review, the only issues the court can actually act on.
The state of Michigan, we are not in the middle of an ocean.
Because the flag in the back got a gold fringe on it.
Yeah, don't even do that bull. That's a bunch of bull.
You have
it is a United States. I don't know what you're receiving, ma'am, but this case was brought by the prosecutor's office on behalf of DHHS because of state aid involvement.
Oh, I don't receive anything. I haven't since
okay, well then once you stop that, then you should be receiving the full amount, but the state will confiscate part of anything that's still owed to them from any child support collected. Right now, I'm not sure how much the arrearage is. Obviously, there is an arrearage. So, no, the UCC, the Uniform Commercial Code, does not apply to this court, sir. This is a family law court.
That you don't have on the gown either, so you're
Yeah,
not.
you're right. That's because I'm an appointed judicial official, not an elected judicial official.
So
yes, I have a full authority. I am sworn in. I am an attorney prior to being in my judicial capacity. So yeah, I have full authority, and the authority is given to me by statute as well. So I follow the statutes, the laws that I have to follow.
So this statutes and codes, it's not actually law.
It's not code, it's law. It's statutes. It's the laws of the state of Michigan.
Statutes and codes.
Statutes, no codes. The Uniform Commercial Code does not apply to this court.
Ouch.
All right. Do you want the child support review or not, sir?
I do want the child support review.
Okay. In that case, I will send this for a child support review. Ms. Cry, any questions, ma'am?
Nope.
All righty. I will look at your motion when I do receive it, ma'am. I don't know when it's scheduled for, but it was not scheduled for this morning. Okay.
Oh, that's what I thought this was for.
Yeah,
Okay.
no problem. This was for his motion.
Oh.
All right. All right.
Mhm.
Have a good morning to both of you. I'll send this to the front of the court for child support review. Have your most recent current pay stub available.
There's,
Both of you.
I'm under the impression that there's a warrant.
Yeah, you do have a warrant.
I didn't notice a warrant, but that wouldn't come up on this file for this motion. That would be a separate issue. You might want to call the warrant department if you believe there's a warrant, because you can deal with that.
I wasn't properly served on.
Again, the court has no paperwork concerning any of your warrant. I don't have her paperwork for her motion. I can't advise on things that I don't have before me because I need to look at them before to find out if they're properly served or not. Call the warrant office and find out what's going on if you believe there's a warrant. This is the first I've heard of it.
This is the motion for support.
This is the motion for support, and that's why I'm sending it to the front of the court for child support review.
And this all is under the same thing. Why they issued the warrant? Supposedly.
No, that's separate issues. This is ongoing support. Your warrant is about back support, if there is one. Okay. Yep. Two separate departments. All righty. Good luck. Have a good morning. Take care, everybody.
You too.
Motion's granted for support.
And when you step back and look at both hearings together, the pattern becomes crystal clear. Two different courts, two different legal issues, eviction and child support, but the same strategic mistake in both, arguing identity and jurisdiction theories instead of addressing the legal substance. In the landlord-tenant case, refusing to identify as the tenant triggered a procedural default, leading directly to eviction judgment. In the family law case, insisting child support was contractual instead of statutory kept the defendant focused on legitimacy arguments rather than resolving arrears or payment review. And courts operate on procedure first, ideology never. Judges are bound to apply statutes, filings, and verified facts, not personal legal theories. That's the core takeaway here. In real courtrooms, participation beats protest every time. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.